Hello, hello. Hey guys, good evening, everybody. How's everyone doing? Great. Had good pizza? Good food? All right. Now let's talk about some health. Tonight is mHealth startups. Hashtag MobileMonday, hashtag mHealth. I myself, I'm Mario Tapia, president of MobileMonday, Silicon Valley. I've been doing this since 1999, so almost a meetup every month. Focus on mobile technologies and mobile topics. So how many people here, it's their first time tonight? Wow, how many people here in health-related fields? Great. So the agenda for tonight is, welcome by me. We'll have Rock from Arent Fox, it's a little bit about what Arent Fox does. And we'll also have a couple of slides from Kabir from Qualcomm. He has an awesome set of slides to talk about a couple of products they've been doing in-house for mHealth. And then we'll also have a panel tonight full of experts from the FDA, HIPAA, and industry, moderated by Pat Salber. So let's have Ross come on up.
Thanks, Mario, and thanks everybody for attending. I'll keep my remarks very brief. I'm really here just to do the law firm advertisement. We're really delighted to be again sponsoring a MobileMonday event. This is second of three that we're sponsoring this year, and have met some really great folks and had some really interesting conversations. Arent Fox isn't a household name here in Silicon Valley. We just opened a San Francisco office in June of last year. We're a full-service law firm, headquartered really in Washington, D.C., but with offices in Los Angeles and New York City as well. We do a lot of work in the healthcare space, and my colleagues on the panel will demonstrate their expertise. So we have, in addition to my group, which is a communications mobile technology group, we have an FDA group, a healthcare group, IP group, litigation, so we can handle probably any problem that you have, and we also have an emerging companies practice area. So without further advertisement or ado, I will turn it back over to Mario, and he will give the rest of the introductions.
Right. Thanks, Ross. Give Ross a hand of applause. Arent Fox has been an awesome sponsor for us this past year. All right, so just a couple of slides before you go into the program. MobileMonday, we're a grassroots community. We're in North America. We're in quite a few different cities, East Coast and West Coast. We're at about over 140 cities worldwide. So pretty much on a night-to-night like this, we have about 15 to 20 other cities around the world are also having a meetup. Here in Silicon Valley, there's about 14,000 of you that have crossed paths with MobileMonday in the Valley. About a third of you are developers. Who are the developers? People who write code. Who are the business development salespeople? Who is product and marketing ideas folks? And do we have any designers? UX designers? See, yeah, I call them the unicorns because there's always like 2 or 3, but everyone wants one. Media, do we have any press here tonight? And bloggers don't count. Okay. All right. And venture, who's in the venture industry? See, I saw, yeah, awesome. Cool, so that's kind of the breakup of our community. So we're pretty active. We do 3 type of events per month. We do this. So this is the monthly gathering of everyone surrounding, and we surround everyone around a certain topic in the industry. And you probably have seen a lot of the stuff we've done in the last couple of months around the Internet of Things. So connected home, connected car. We have wearables coming up in November. I think security coming up in October. But also we do stuff focused for folks who actually write code. That's called the MobileMonday Labs. We have one coming up next month with Digital Globe. How many people know what Digital Globe does? So most of the satellite imagery that you see on Google Maps is produced by Digital Globe. They're a US-based company out of Colorado. And they have some awesome, fantastic new satellites that just went up about 2 months ago. So it has awesome resolution. So we'll be doing something in October. Watch out for that. And then we also do the CXO dinners. So this is kind of more of 25-person VIP, invite only. And again, we center the topic around a certain vertical in the industry to discuss. And it's mostly Fortune 500 leadership and founders of startups to mingle. If you guys are interested, you guys reach out to me about the dinners and the labs and also meetups. Also, where to find us at www.mobilemonday.us. You can find out, pretty much all the upcoming meetups that we're having. Also, look for us on meetup.com. Our Twitter handle is MomoSV. Facebook, you'll also find photos of tonight's event. And thanks to some of our awesome volunteers, we also have our historian documenting these events. So we're over 50, I think, now that we have on online. But YouTube, Mobile Monday SV, we go back quite a few years. And I think John's in the back here manning the camera. And then something new that we've been doing called Mobile Monday University. And this is really a day-long deep dive into a certain technology. This one is going to be about iBeacon and Apple Pay. This is on Wednesday. The former head of retail for Qualcomm will be giving this one-day seminar. And it's a really good deep dive. I don't know how many people went to the Beacon event a couple of months ago. So it's Steve, who also gave the keynotes, is also teaching this class. He's probably one of the best experts in the industry right now for retail and how to engage in brick and mortar using Beacon technology, and is very familiar with what Apple's doing on the Apple Pay side. So that's we still have like 5 seats left for that, and that's an all-day session from 9 to 5 on Wednesday. If you guys are interested, this will be a really good kind of grounding for you on the Beacon technology side. The team can't do this all by myself. So we have Monica, who's been awesome. She's over here. She helps organize all the treats and food and stuff like that, and really kind of brings order to all these events. Chelsea, you've probably seen her around. She'll also be social media and tweeting. She also helps out along with Stephanie. Stephanie's somewhere. Where are you, Stephanie? She's there in the back, and she's probably turning a little bit red now because she's very shy. And then John at the camera. And then I think Ryan also just stepped out, but he was around today. Thank our sponsors, tweet about them, reach out to them. So there's at Qualcomm Life, and you can send some thoughts out to them. Arent Fox as well, you can reach out to them on Twitter and Microsoft. And also Mobile Monday, MomoSV is our local handle for the Silicon Valley. So basically, like, why mHealth? And this is actually second time we've done this topic. Last year in January we had an awesome topic, and I've never seen so many Q&A questions come out. I think we almost did an hour worth of Q&A, but hopefully we don't take an hour Q&A. But it'd be great to have you guys participate. I think this is going to be a very interactive session tonight, and where we are going to request audience participation. So kind of an overview of, we're really looking at tonight the premise of, what if you're rolling out a new startup and that's mHealth focused? And I know in the Valley we do software very well. We don't comply or do regulatory compliance too well. And so some of these acronyms look familiar: FDA, HIPAA, etc. And those are some pretty serious stuff. And so we'll kind of walk you through some of these pitfalls, and also talk about funding, because you can never have too much funding, right? Just like education. Patenting, like, hey, I got this great idea and I want to patent it. What can I do about it? Also, how do I market my new product, etc. And also, what are the new technologies that are out there? Just like the stuff that Kabir was showing you from Qualcomm. There's some awesome stuff happening. So we'll take a good overview from that. So don't be shy about your questions. There are no dumb questions in this room. We're all entrepreneurs and founders, and basically people who never made a mistake, really never tried anything, right? So just keep that in mind for tonight. So I would like to introduce our moderator, Pam. And I have some interesting words here. Sorry, Pat. Interesting words here. So Pat is an internist and emergency physician, and also held the CEO of HITECH, a resource for health technology startups to tell their stories to the world. She is also the founder of the host of The Doctor Weighs In, a popular healthcare blog with terrific original posts on clinical and health technology topics. As Doc Weighs In on Twitter, she's one of healthcare's leading voices in social media. Be sure to follow her at Doc Weighs In. And so, without further ado, Pat, I'll hand it over to you.
Thank you. So before we get started, I just want to learn a little bit more about you all, because I know we have developers and designers and people on the technical side in the audience and a handful of funders. But we're talking health tonight. So how many people in the room are clinicians? Okay, fewer than there are funders. And how many people are patients? How many people are real patients with, chronic illness or have to see a doctor more than for a cold or sore throat? Okay, and how many people are caregivers? Yeah, just one. Okay, and how many people, of those of you who have startups, have any of those categories of people involved with helping you develop your product? Okay, all right, good. So what we're going to do tonight is I'm going to tell you about my new fictitious company. And I'm going to invite all of you to be a part of my team, because we're really lucky that we have all this incredible talent with us up here, and they volunteered to give us free advice. So let me tell you a little bit about this company. It's called Best Ever mHealth. And so our acronym is BEM. And what we're doing is we're developing a platform that will allow us to get to a diagnosis quicker, cheaper, and more accurately than what's happening currently in the context of the doctor-patient relationship. And because this is Silicon Valley and we have to talk about big data, I just want to let you know that the way we're doing it is by analyzing big data. And of course, we're going to take our services all around the world and have it in many different languages. And our whole technology is based on proprietary, evidence-based algorithms that are backed up with a panel of the best-in-class physicians from around the world. So we have both high-tech and high-touch. And since this is my first startup, guys, I don't know anything and I got a lot of questions for you. But I want you to know that my team out here, I'm pretty fortunate to have acquired a team of like 100 people already, is also going to ask you questions towards the end. And we want to let you know that we're really passionate about what we do, but we're a startup, so we're talking about money. Important to keep that in mind. So I thought I'd start out with you, Tom, and I'm going to ask you to, before you answer the question, just to give a few lines about your background so we understand you're an attorney, what kind of attorney you are, and what your expertise is. And then my question to you is, do I really have to hire a lawyer for my company? You guys are really expensive.
You're asking a lawyer that question?
I am, but wait, I want to tell you what my alternative plan is. I heard I could just go online, right? And I could download some forms and write a check, and my brother-in-law told me I could be an LLC. So I kind of want to know what you think about all of that.
Maybe there's an app for that.
Well, if there is, let me know.
Thank you, Pat. My name is Tom Jeffry. I'm with the healthcare group, which is under the regulatory sort of division of Arent Fox. And we have 80 attorneys who focus on healthcare regulatory types of issues. There could be payment issues, they could be practice of medicine issues, they can be healthcare privacy, HIPAA issues. Someone told me once that the healthcare industry is the second most regulated industry in the country, second only to nuclear energy. So there is quite a minefield out there. I also do some transactional M&A contracting type of work as well, because you need to know the regulatory side of things to, I think, make the right business decisions. And so making the right business decisions is kind of where you're at, Pat, right at the moment. You know, creating a company or creating an entity is pretty simple. I kind of analogize it to the act of creating a child is pretty simple, and you don't need a lot of help. But there's a lot of repercussions after the child comes, and that's when I think good planning and consideration of some of the factors of what's going to happen after you incorporate or create that entity, that you really, I think, should have an attorney be with you to sort of ask those types of questions. You know, for instance, there's a lot of people in this room who are on your team. Are you going to give them a little piece of the action? Well, again, a lot of these organizational types of questions, if some people, I think a lot of the out-of-the-can online types of things are good if you're a store owner and you're not going to have investors, you're not going to have people you're going to bring on later on. It's just a matter of keeping your liability separate from your personal assets. But there's so much more, I think, with startups, and you can so mess up or make decisions that you're just going to have to undo and redo. And sometimes the undo and redo can be painful. For instance, you created a limited liability company here in California. You think, well, what could be wrong with that? Well, you're stuck with one class of owners. And so if you want to go out and get investors, now they typically want different types of classes, have different types of priorities. Maybe you want to have an LLC in Delaware. You're not going to know that or understand that unless, I think, you talk to an attorney. You may have one of your investors or somebody who you want to be part of the corporation who's from a foreign country. Well, that's fine, but if you incorporate, you don't have that S, what we call Chapter S election that allows for pass-through, and you're going to face double taxation issues or problems. So there's just sort of a lot of planning things that is important to have an attorney there. As Ross indicated, I'm part of the sort of the startup entrepreneurial group, and I hear what you're saying. Startups don't have a lot of money, and attorneys, except for tonight, don't like to give out a lot of free advice. But there are, I think, some things that we believe that planning is so critical that Arent Fox, and I think there are other firms that do this as well, will try to sort of negotiate a discounted set fee for kind of what I call planning hours or planning purposes, to answer some of those questions, to figure out what it is that you want to do, where are you going, and then to work within that budget, and then as you need to implement things, maybe for a period of time, not indefinitely, but maybe triggered to a funding event or that type of thing, defer a portion of the fee. So again, I think you often will regret not doing the planning and not doing planning with the right legal and accounting resources if you go that route.
Okay, so that's really cool. What you're saying is that you'll give me a discount, you'll let me pay it later. How about if I just give you a little equity?
Yeah, there were a lot of firms that did that, particularly in the 80s. I just don't think that that's kind of the way to go. And the other thing is, I'm not sure you want your lawyer to be your investor, because then they have a little bit of a sort of an internal conflict of interest, if you will. I think it's good to have a little bit of a separate relationship where I'm retaining you, but we have this sort of understanding so that you can wait a little while to get paid for some of your fees, not all of your fees, for some of your fees until we kind of get launched.
Okay, so it sounds like it's really a worthwhile investment for me to be sure that I set this thing up the right way, and I don't have to pay later. So, so Imran, if you could say a little bit about yourself in a second, and then I just want to let you know we've been really busy, and you know those algorithms that I talked about, we've actually coded them. They're done, you know, the world hasn't seen anything like that. That's why we call ourselves the best ever. But we're now starting to talk to funders, and these guys want to see our algorithms. They actually want to have the detailed description. And you know, I'm a little bit worried about this. I actually haven't had time to do anything about patents yet. Should I give them this stuff?
Well, man, that's a really good question. I'm glad you came to me. I'm a patent attorney at Arent Fox, and I help companies and entrepreneurs and startups like you who are seeking patent protection and IP protection, and you navigate these complex issues. So one thing I do is work with inventors, help them identify what may be patentable or what may not be patentable, decide whether they want to file in the US or file abroad, and help them develop a patent strategy and eventually get their IP and then monetize it and exclude their competitors or use those patents for defensive purposes. So Pam, getting back to your question, before you run off to that meeting, it's very important that you decide whether you want to seek IP protection, because if you go to this meeting, even with an NDA in place, and you haven't filed a patent, anybody can leave that meeting and file a patent the next day. So even if you are the inventor and did have the idea, in the US now we're on a first to file system, so it's no longer enough to be the first inventor. So it's important to get something on file, and you have an option of filing a provisional patent application. In the US, if you file a provisional application, you have 1 year before you can file the full application. It's a relatively inexpensive process, and you could consult the patent attorney, get that on file for a couple of $1,000s, depending on the type of technology that you're discussing. And that way you give yourself some protection before you go into that meeting. Another thing you mentioned was an algorithm. How many people think that software is patentable? Okay, so I think I saw like 5 hands. How many people think that software is not patentable? It sounds like the majority of people think that software is not patentable. It actually turns out that software is patentable. And even though you've probably heard a lot about negative things about software patents and business method patents, there are actually 2 types of patents that get confused, which are business methods and software patents. So a business method is just any sort of method of doing business, like making a stock trade or whatnot. And so what's happened since the startup and .com boom in the 90s is that a lot of companies filed patents on business methods and simply put them on computers. But what it sounds like you're telling me is that you have a novel algorithm that can help you efficiently mine patient data.
The best ever.
What's that? The best
The
ever?
best ever.
That's right. So a novel algorithm which can help mine data and make the healthcare system more efficient. So what I would suggest in your case is that you do have what I would deem a patentable invention, that you file a patent application and protect yourself before you run off to that meeting with the investors.
And then I can start talking about it.
You can start talking about it. And another thing I should mention is that in the US you have a grace period of 1 year. So even though you may disclose your invention to somebody, you have 1 year to go get patent protection, and so your own disclosure won't be used as prior art. That's not true necessarily in all countries. So in Europe, if you have a European IP strategy, if you make a disclosure, that could become immediate prior art to you. So really depending on what your strategy is, it's always good to get a provisional application on file rather than wait for that 1 year grace period to expire.
And so prior art, that means if I tell somebody about it, now all of a sudden it's not patentable?
It won't be patentable if you wait a year in the United States, but in Europe it could become immediately prior to you, and you can lose your invention that way.
that's pretty scary. Hey, Kabir, I'm so glad you're here because I want to get your advice about what we're building out. It's our thought that we should build this out as a web-based platform. And we're thinking, I don't know, like eventually we'll do mobile. And we want to know what you think of this strategy.
Well, I'm from Qualcomm, so mobile is always going to be the first thing I mentioned. But I think when you're developing a solution, look at it from a service standpoint versus looking at it from an app or a website standpoint. And figure out essentially a platform agnostic strategy where your service can run on any platform. If you want to choose to build your own lighthouse applications, I would choose a platform agnostic approach. So for example, a browser-based approach that then runs on any platform, so you don't have to make a choice between a web or mobile. But most importantly, always look at a long-term strategy where you're more of an enabler. You're a behind-the-scenes component that can then, just like you can Facebook connect into another, your Netflix account or your other services. The key thing is to figure out a way where your platform essentially enables an open ecosystem. I really feel any service is only as strong as the ecosystem that it builds. And for you to build an app or a portal, that should just be one endpoint for your service. It should be all about building enablers that then get you sticky to get to those other locations and then draw users from that location back to your platform. So essentially create that dual bidirectional strategy. So think of an app not as the kind of purchasable, monetizable component, but rather the endpoint to your service that's essentially driving your revenue. And then you don't have to worry about whether it's mobile or web. You've built your lighthouse app and now you're becoming an enabler for other developers. And there's lots of creative ways that you may not even think of that your developers are going to think of to take your platform to the next level.
Well, it's a good thing I talked to you. Hey, Tom, I want to tell you a little bit about how we're going to collect this data. We're going to integrate with the EMRs, and then I have this great idea. We're going to have them fill out a 55-page health risk assessment. So we're going to know everything there is to know about this patient. And then we're going to have them, just email the results back to us. But, somebody told me maybe we couldn't do that. There's some privacy concerns. What do I need to know about privacy?
What do you need to know about privacy and healthcare information? Well, Pat, there is on the federal level HIPAA, which is the Health Insurance Portability and Accountability Act, and it has a whole lot of provisions related to the privacy and security of healthcare information. And the healthcare information is identifiable healthcare information, so where it's information about a person's health or condition and their identity, and it might be something besides just like a name identifier. And of course there are state laws as well. In California, the Confidentiality of Medical Information Act that also has its separate provisions that if they are actually more strict than HIPAA would apply. So you've got a lot to think about when it comes to healthcare privacy. I don't know who's going to give you the keys to the EMR record because I don't think the hospitals and physicians are going to necessarily open that up to you because of their own HIPAA concerns. They are subject to, they are covered entities and have to abide by HIPAA. So it would seem to me that unless you were working for them or under them, in which case you'd have to be a covered entity, a business associate, which means that you've got to now comply with all this HIPAA stuff, and it's pretty onerous. You would want them or your customers to provide authorization that would allow them to transfer that data over. As long as you're not one of these covered entities under HIPAA, you're not a provider of healthcare, you're not a payer of healthcare, you're not creating some sort of link between the payers and the providers, and you're not a business associate, you're not doing something on behalf of one of those, then the health risk assessment that a patient voluntarily gives you wouldn't be subject to HIPAA. That doesn't mean, though, that they're probably, you still want to protect its security and privacy. And there may be state laws that you would have to worry about. And of course, didn't you say you wanted to go to Europe?
Oh, well, yeah, but we'll talk about that later.
Okay.
So Kabir, I know that you're an expert in user experience, and I just kind of wanted to know what you think about my wonderful 55-page health risk assessment. Pretty good idea, don't you think?
Not at all. I think to me, user experience goes hand in hand with user empathy. You really have to look at it from the point of view of the user. In our case, our users are grandmas, and that definition of grandma is actually changing now. You actually see baby boomers are becoming grandmas, and they are very savvy with Facebook, they're very savvy with tablets and iPhones. You have to figure out who your audience is and build to that. We have built two separate platforms, one on the data collection side. I mentioned TuneNet very briefly, but that essentially takes away the connectivity aspect. So grandma steps on her weight scale, that reading goes to the physician. She doesn't need Wi-Fi, she doesn't need Bluetooth. All of that's already taken care of within the context of the system. And then we have another platform that's collecting all of that data and taking all of the consents that we just heard we need so that my EMR information is right next to my weight scale reading or my blood pressure reading. So the key thing I would say from a user experience standpoint is put yourself in the shoes of your users, and you might think you're doing that and then trying to get to the lots of constituents, but focus on one specific constituency first and go really deep into that, because if you win just that, you might have already gotten a successful business going.
Well, I'm getting a little discouraged here. I thought I had some good ideas, but no, I do have one other idea. Tom, I'm going to ask you about this one. So we have these really cool docs all around the world, or let me put it this way, we're going to have these really cool docs all around the world who are going to give advice. So, this is our high touch part, and we're going to give them access. We thought we were going to give them access to all the data that we've collected. We certainly can give them access to the health risk assessment data, and then we're going to have the patients, write questions in. And we thought this was really a great idea, but some of my doctor friends are telling me, no way are they going to do that, because too much liability. Is that really true?
Well, if these physicians are creating what we would call a patient-doctor relationship, yeah, that liability attaches, because in essence, they are saying, you're my patient and I'm responsible for what happens to you for the care.
So I just buy them some malpractice insurance, right?
Well, that's a possibility. You can always insure around a risk, but there's another problem, Pat.
Oh.
The practice of medicine is regulated in every country and then in the United States by each individual state. And so, for instance, here in California, a private lay corporation cannot employ physicians. And so if you were to hire doctors to give advice to patients, to in essence treat patients, then that would be considered the practice of medicine, and you could go to jail for that. So
things are getting really bad here.
But let me tell you, not to be totally pessimistic, I think that as you're developing this, there is a line between providing medical advice to patients and providing them education. So what is their data? What are the normal ranges? What does this maybe mean without making it, this is a specific diagnosis for you, or this is what it is, and then encourage them to take that information, or maybe what Kabir was saying, within that circle of life type of thing, so that their family physician, their own physician, can pick this up and say, okay, now I've got some information, I've been educated, but I'm going to my own physician to get the treatment or ask the specific diagnosis questions.
So the fine line is I can give educational information about tests that I've gotten or information that I got from their health risk assessment, but I can't tell them, oh, you have X disease.
That would be correct. In other words, you don't want to give them a diagnosis or a treatment or that type of thing. But you could indicate people with these test results may have this type of condition which has these types of consequences. And again, you want to always encourage them, remind them that this is not the same thing as going to their physician, and encourage them as part of that to see their physician to discuss it further.
So I want to drill down just a little bit more. So if I have a doctor from Indiana and a patient from California, can that doctor from Indiana give educational advice to the patient in California?
He probably could give educational advice, but again, and there were, for instance, you call up an 800 number, you talk to a physician, you get a prescription filled. So there is that out there, and I think those doctors either don't care about their liability or malpractice may be fine for them. So I don't want to say that it isn't possible, but here's the issue. That physician who that patient talks to typically has to be qualified or recognized by the licensing entity to practice that type of medicine in that state. So you're going to have to do a 50-state survey, and typically, I think for most states, you're going to need a physician who's licensed to practice in that state to talk to the patient from that state.
Okay, so that's getting a little expensive. I heard there was some legislation pending to eliminate this and have a license that would be good across states. Is that true?
I haven't heard about that. I could sense that there would be, it would make things a lot simpler for a lot of people. But again, that's been a very state regulated type of thing.
Okay, well, pretty discouraging. But it's a good thing I talked to you. So now I'm going to get into another area that I have had a lot of concerns about, and I'm going to ask you, Wayne. We want to know about FDA clearance. Does this thing we're doing, do you think we're going to have to go through the FDA, and is there any way we can avoid it? You know, we are actually thinking about developing a device that would kind of be like TuneNet, but sounds like somebody bigger than us has already done that. Can you explain this FDA thing to me?
Sure, be happy to. I'm Wayne Metelsky, and I'm an FDA lawyer, and the hardest part of being on this panel was waiting to speak until now. A lawyer doesn't like to wait to speak. But I've waited quietly, so now I'll monopolize the floor. Now, please, if you have any questions, please just interrupt me. But really, with FDA, and Kabir was talking about the difference in the papacy over how many years, 7 years, whatever. With FDA, it has been the same type of thing. The FDA is a high-bound, tradition-bound agency that moves very, very slowly. However, in the medical mobile app area or the medical platform area, they've moved surprisingly fast. It won't seem fast to you, but it is fast. In 1989, they published a policy guide. In 2011, they published a draft guidance that was really worthless. It just regulated medical device, mobile apps as medical devices. And then in 2013, they published this, which was a guidance on mobile medical apps. 2013 in September of 2013. And since then, FDA has published a revision in that in June of 2014. That's moving with lightning speed with the FDA. They don't like to move that fast, but Congress, the administration, and a lot of people have urged them and forced them to move, and FDA, to their credit, has moved. Now, to your question, what would this require FDA regulation? It depends on what we're trying to do. Kabir, you mentioned recording weight from a scale and putting it into your medical records. That does not require FDA regulation. But if something regulated for instance, if you had a blood pressure cuff and you had a device that inflated the blood pressure cuff, that would require FDA clearance or FDA regulation. And if you did more than just give advice or regulate a device, it depends upon the function of the device and on what you're doing. I'll read you a couple. It's a very fine distinction. For instance, apps that transfer, store, convert, format, and display device data without controlling or altering the functions or parameters of any device are by FDA has decided it will not regulate at the present time. And I say at the present time because FDA has used this euphemism of enforcement discretion. They think they can regulate it, but they've decided that because of whatever, they're not going to regulate. They could in the future, but right now they're not going to regulate it. But if an app does more than that, then it's a very fine line that you have to really watch, and it's a very difficult thing.
So how can I know? Do I have to come to you?
Yes? No, I mean, you can read the guidances.
Can you give some examples of that? The difference between that, what is, you mentioned the differences.
Sure, be happy to. And I'll
Excellent, because only 20 apps approved so far. We have 40,000 healthcare apps. We have only got approved 20 for the 3 years. I want to know what that guidance, lightning guidance plan.
Yeah, the guidance that I showed you is full of examples. Of course, they don't mean what you want to know, but they are full of examples. I mentioned the apps that control blood pressure cuffs or insulin delivery. Those are regulated by the FDA and require clearance. Attachments of EKG electrodes that actually perform a function to measure EKG, and this is transmitted, and a diagnosis is made from those. That is regulated. If you just transmit information without connecting, without actually giving a diagnosis or anything like that, then it's not regulated. So it is essentially apps. I'll read you one example again that FDA. It's a very fine distinction, and if you can understand this example, I admire you. Data from bedside monitors. Data from bedside monitors. Apps that display medical device data to perform active patient monitoring are subject to FDA clearance. Active patient monitoring. But apps that connect to a nursing central station and display medical device data to a physician's mobile platform are not regulated. So if it deals with active patient monitoring, in general, that is regulated by the FDA, or will be regulated or cleared by the FDA. Apps that don't do that generally are not regulated. The key is whether the app or the platform could cause patient problems if it were to malfunction. If it were, then FDA wants to have some say in it.
So what about my algorithms?
It depends on what your algorithms are trying to measure.
I want to get to a diagnosis, but I'm not going to treat.
But if it's solely giving information to the doctor that the doctor or the healthcare practitioner will confirm with another diagnosis, then it is not regulated by the FDA at the present time.
So it's just giving advice to the doctor. It's not.
Well,
regulated?
it's being confirmed by the doctor.
Oh, okay.
It's being confirmed by the doctor. Obviously, weight, to use Kabir's thing, weight can have all sorts of ramifications, and that's transmitted, and the doctor can look at that weight chart and make a diagnosis that perhaps the person has diabetes, whatever, all types of things. But the doctor will confirm that weight when the patient comes in, or by some other method.
We have a question here.
Oh,
Yeah.
sorry.
Yeah, a long time ago, we used to have medical devices connected by the phone lines to doctors, whatever.
Yeah.
And they said that the phone lines were not part of that FDA-approved device. Now, when we're trying to replace those phone lines with other communication methods, I heard that those had to be approved. Can you comment on that?
Sure. It depends on what you're transmitting. If you are transmitting pictures, for instance, from a tablet, from an iPhone or something like that, and I'm using this iPhone so I can write off my iPhone 6 Plus one. But this is not a 6 Plus. If this is transmitting. If I show it Tom's arm, and he has a sore on his arm, and it's transmitting, and that is being diagnosed by the transmission, obviously how it can be transmitted and the contrast and everything else is subject to all sorts of parameters. FDA will regulate that if you are transmitting a picture or something like that. If you're just transmitting a weight, to use Kabir, I'm overusing that, but or other parameters. If you are transmitting blood pressure manually or electronic blood pressure values, that's not regulated by the FDA. Yes?
I guess my question is, how far down the chain does the regulation go? So there's the application, but then there's the phone, and then there's the wireless network, and then there's carrier network. How far does that have to be approved? Does that make sense? The data transmission.
The data transmission, that's a hard question to answer. If it's generally the manufacturer of the app or the platform that has to get the approval of the FDA. Does that answer your question? I mean, but obviously what the doctor sees at the end of the line has to be viewed and regulated by the FDA if FDA is going to regulate it.
So I'm not the legal guy on this panel, but the way, just to answer your question in a slightly different way, whoever makes a certain claim has to meet that claim. So if you're a transmission pipe, but you're not actually saying you're doing it for medical purposes and that you're actually a medical pipe, it's different from just saying I'm just a transmission pipe and somebody else is using it, and that person who's actually using it and marketing that app or that device, that endpoint as a medical claim-causing entity, that's the person who has to be subjected to meet that particular claim. So I would look at it as, what are you actually as a service provider claiming you're doing? And then the FDA can say, okay, if you're claiming to be a doctor that you're going to replace diagnosis, then I think you are subject to meeting the claim that you've made. So I wouldn't think of it as like for example, an iPhone wouldn't be subject to it if Apple didn't say that that was a health device. But somebody else was using it on an app on it, that app developer would be subject to that because that was the claim they were making. That would be...
And you're exactly right. FDA has specifically exempted Apple and the other companies that do those types of things. But the app itself, the claims that are made for the app or what the app does are regulated. It's the manufacturer of that app. Or the development specification developer.
Hi, I was told to introduce myself, so my name is John Lockney, and I've looked at some of this health and wellness for a number of years. I was originally working in Nokia at the time, and we decided not to because of all of the FDA things. My question is, well, actually, I've got two questions. First is one about Pat's magical algorithm. We here in Silicon Valley love deep machine learning. We love data. Now, we can infer from data a heck of a lot of things, and we're going to be entering a world where we're collecting a heck of a lot of data. We can process that data, and maybe we discover some things that if you have a weight of a certain type, a temperature of another type, a blood pressure of another one, that means something significant. But now, is there a certain amount of, let's say, clinical trials needed from the FDA point of view before we point out, hey, now you're doing something medically significant? I sort of look at something like 23andMe, which is obviously a Silicon Valley company that sort of ran afoul of FDA because they were making claims that certain genetic sequences may imply certain, cancer types or some other things that that you as a user should look at. So what is the burden when we're talking about this sort of algorithm and the sort of data analytics? Do we need clinical trials to be ordered to sort of get approval, and what's the risk if we don't?
Well, once again, it depends on what you are doing with those data that you are collecting. But in general, those types of things, if you are using genetic testing to make a diagnosis of some sort, in general, the FDA does say that requires clinical testing. If you are evaluating various parameters and you make a diagnosis that a person, a doctor, or even a patient is going to rely on, that requires clinical testing in order to get clearance from the FDA. Depending upon what type of thing you're doing, it depends on the type of testing that you need. But if, as Kabir said, if you are making, it depends upon the intent of what you are promoting this product for and what you are labeling the product for. Intent and labeling are essentially the same in FDA's term. What you are labeling terms. If you are labeling something in order to diagnose a condition, then it does require, in general, clinical testing. Yes. Sorry, I can't say yes. Okay, wait for the mic.
Alex, I have a very fundamental question. Who owns the data?
Yeah, that's a good question.
Because everything, whatever you do with the data, I don't care, but who owns it? That's the more important question.
That is a very good question. So let's go to our hypothetical here. If you have that risk assessment that the patient voluntarily put together, and of course, part of your, when a person signs up for this new application or whatever, they're going to sign in terms of use. We really haven't talked about that, but that's going to be very important in terms of settling that issue of information that the patient directly provides to you, and that terms of use will say what the company can use the information for, what its responsibilities are, disclaimers, that type of thing. Now, what about the data that we get from the electronic medical record? The providers, the persons who inputted that data are going to claim that that's their data, that's information in the medical record.
I don't think it's correct.
Okay. What you're saying is that if a doctor has a record, that it's not his record? The consumer has, under California law and most states' laws, and even under HIPAA, the consumer has the right to request that information, get a copy of that information, or request that information be transferred. The consumer under HIPAA has a right that if it thinks that there's something incorrect in that record, to go back to the provider and ask for it to be corrected. And there's a process. The provider doesn't necessarily automatically have to do it, but that means that the provider is legally responsible for that medical record that it obtains. If we ship a copy of that electronic medical record, or we make it available to Pat's company, then that information pursuant to the authorization can be used. But Pat can't claim, oh, that's the patient transferred that information to me, you no longer can use it, medical provider who put in the data to begin with. That's not true. You're going to assert, as the physician or the hospital or whatever, this is our medical record, our patient data. Again, if the patient authorizes it, we will give access to or give a copy to Pat and her company. But that doesn't mean she owns that information.
But it is definitely the patient's right and record. But the patient can give that rights to that to other people.
Right. So, and that's what I'm going with this. So the patient is the ultimate control of the data. You cannot, if the patient says, I want this data from Kaiser, for example, and the Kaiser must provide this data to either the patient or to whoever the patient assigns to receive this data.
But there's some interesting nuances here that are coming up with other ways of collecting data, and I think the big one is with the automatic implantable defibrillators, and there have been some activists who want to get the raw data and have been unable to do that, and my understanding is that that the law is not on their side.
Correct. I noticed a slight accent. Laws in Europe are much more stringent than they are in the United States, and the patient does have virtually an absolute right to his or her data. In the United States, the patient can assign those data to other people in certain circumstances if they give the permission. Right,
Yeah,
Tom?
in other words, all I'm saying is you cannot, the patient cannot tell the hospital or the doctor, I want you to erase all of my data. They can request that you provide a copy to someone else, but they can't request that, they can't yank that information or data away from the provider. So they have the ability to control, to get a copy themselves, to direct it to someone else, but they can't dictate what's in that record, and they can't have the provider eliminate it altogether.
That may be different overseas. I think in some...
In the United States.
That's in the United States.
In the United
But
States.
overseas, there are some countries where the patient is supreme and has the absolute right to get that data back and stop anyone from using it.
You guys, you could take it offline, just roll to the next question, because I think, I don't want to kill who owns the data, we can talk about that all night. Right? Let's go to the next question.
Unfortunately, my question follows the same question. But just to simplify the issue, if the data of one patient is worth $5, who is getting the $5? Who is Pat going to go to acquire this data? Are we going to the patient, asking the patient to authorize this data and give it to Pat, or are we able to go to the provider and pay them for the data that they own the right to?
I can take it from a business perspective, not from a legal perspective. We get this all the time because we aggregate data, and there's multiple entities who are responsible for it. So we move away, and actually the industry's moved away from ownership to access, and I think that's what Pat alluded to as well. And what we don't realize is, as patients, when we go to the clinic or the hospital, we sign like a gazillion forms. Those gazillion forms essentially tell everybody around that they can create records on our behalf. They don't necessarily have to take our consent when they're sharing it with some other specialist physician. All of that, so in some ways you've already given that consent, right? So who has the access to the data is based on who's given consent at what point and who generated the data. So when your $5 question comes up, it's really around how much of that access do I have. It's all fluid. It's all cloud-based these days. Even the EMRs, to a certain extent, we've noticed now, if the right entities consent to that data, the EMRs are simply then having to divulge that information. Everyone is trying to do the right thing. So it's not that one person trying to hoard the data, but it's also about ensuring that you as a user are giving away the rights at the right time. You're not actually giving that away and then you're asking for it. But there's also safeguards that are coming into play, like the Blue Button initiative, where the government is saying, if I want access to my records, I should have the ability to quickly, within 48 hours or within 72 hours, get that information as well. So if there's one thing I can say is, go away from ownership and move away to access, and figure out if you have the right consent from that particular entity, and then you can have a copy of that information just like everybody.
And that's true with clinical testing. Someone mentioned clinical testing earlier. Normally, you have to sign an informed consent form that assigns what the investigator can do with those data. And it depends upon the extent of that. But the FDA and others have put restrictions on what you can do many times with those data. So you have to look at the FDA and governmental regulation along with what consents have been signed and the extent of the consent.
The other thing that I'll just sort of add to this is you talked about sort of paying for data. And obviously data has value, particularly to marketing, advertisers, that type of thing. HIPAA has very specific restrictions and prohibitions about for covered entities selling data without the authorization of the patient, or even how a patient might be approached for those types of purposes. So that's an area that is very highly sort of restricted. And again, in our scenario, the concept was the patient is so eager to use the app that they give the authorization without it.
Mr. Jeffry, I have a question for you. The hypothetical question for you. That you said that a doctor from Indiana giving advice to someone in California, that's kind of a charging practice without a license. What about how do you enforce a law? Somebody, a doctor from, say, one letter, you take it up from India, giving advice to the patient in California. What kind of laws govern them? And if the consumer really goes and decides to go and take advice from that doctor, what kind of laws govern in that sense? Can you explain that one a little bit?
Yeah, and of course, let's sort of put this on context in terms of, I think we live in a world where regulations, and we're talking about state laws, have certain jurisdiction. So if I am sitting here in Mountain View and I am interacting with, let's say, a physician in India, and that physician is quote unquote treating me or giving me medical advice here, then I think the state of California, the Medical Board of California would say that physician in India is practicing medicine in California because the patient and the treatment or the advice is coming here in California.
How do you enforce that?
Enforcement is a whole different issue and question. But again, they probably will not be able to get the physician in India or try to even extradite them. But I'm concerned about the entrepreneur who is located here in California, who provides the device, and they will go after them. Yeah, that's right. So I'm concerned here that Pat is going to get a knock on the door, and of course she is a licensed physician too. So the medical board will have even more fun with you.
Team, any other questions?
If it involves a medical app that's, for instance, sold over the internet, FDA may very well shut it down from India, from any place else, if it violates US law.
Hi, my question is for Wayne. Wayne, I come from the medical device world, and the clinical trials are, there's 510K and PMA. I wondered if you could just speak to what the FDA has said about the scope and how many patients and what kinds of clinical trials they're expecting to see for these types of mHealth apps.
I'm going to have to give you a lawyer answer, and I apologize for this. It depends, is what I'll have to say. It really depends upon what the types of claims you want to make for the device and how you have to prove that. There are two types of approvals from the FDA. This, you know this, but for others, there's a clearance through the 510K notification process. That's a relatively simple process. And then there's pre-market approval, which is a very lengthy, very intensive review by FDA. And generally for mobile medical apps, at worst it will be probably a 510K notification, in which case you do not have to go through the full clinical trials that a PMA, pre-market approval application would need. In other words, you don't have to prove the complete safety and efficacy of the mobile medical app, but you do have to prove that it is that the parameters that you are testing for actually you're actually meeting those parameters. Inflation of a blood pressure cuff. You have to show how that inflates, deflates, and things like that. You don't have to necessarily, and that it gives accurate records, accurate readings based on existing technology. You don't have to go back and prove that blood pressure is a parameter that needs to be measured or something like that. So it depends upon the types of claims that you want to make. You don't have to reinvent the wheel for 510K notifications, but for any claims that you're making, any parameters that you're establishing, you have to show those if it requires 510K notification clearance. Most of the apps that we've been talking about would not require 510K notification unless it actually the device actually does something, inflates, deflates, glucose, sugar, whatever. Yes?
Yeah, I understood from Obamacare there was a new tax levied on medical device manufacturers, and I'm not sure where that went or if that got removed and what that applies to. It was a 13% revenue tax.
Yeah, there is the tax. It has not been removed to my knowledge. Do you know?
No, I just reviewed it, it hasn't been removed.
It has not been removed. There's a lot of action in Congress that wants to get it removed, but it has not been removed. Does this apply to mobile medical apps? Arguably, yes, because they are medical devices. But here you get into the whole range of whether something is a medical device or not. And that if FDA has, there's a medical device, there's a definition of what a medical device is that is for diagnosis or treatment of a disease or condition in man or other animals. And if it measures that, then you have to make a determination of whether it falls as a medical device within the parameters of the taxing statute. And that's a difficult issue right now with mobile medical apps because a lot of them FDA says it won't regulate. So I would make the argument, and I haven't looked at this, but I would make the argument that for many mobile medical apps, they are not medical devices and should not be subject to the tax on medical device tax. But it will depend upon what IRS has put in its regulations about that. I don't think they've dealt with mobile medical apps, but I'm not sure.
But if you do have a device, if you do have a device,
Is it 13%? Is that the number?
Something around that, yeah.
That's in addition to all other federal taxes, correct? So they're
Correct.
Or state taxes.
Yeah. Correct.
right. So I know, like, bad companies are now moving out of the country and so forth. So,
But if they're selling in the United States, they
Then
still
they
have to pay
can.
it. Arguably.
I don't think mobile devices were the concern
No.
in the legislation. I don't think the intent was to go that far, but again, intent, I think, sets up the argument of why they shouldn't be included, but that doesn't mean that the IRS or one of the other agencies might not have a different point of view. So I think there's probably going to be a little bit to see what, if anything, Congress does on it. I don't think the IRS has beaten down the door to try to enforce this or pull it through, so it's going to be kind of a stay tuned type of thing.
And Congress won't make any action this year because it's not making
So
any action.
I'm going to just ask the audience a question. We can continue along the lines of the regulatory environment, or would you like to have some questions and answers around funding? I know we have some funders in the audience. What's your choice? Regulatory funding, shout it out.
Funding.
Mind if we make a left turn then and
Or
talk?
right turn.
Or a right turn. So funders, can you raise your hands again? I'm going to want to have you guys participate as well, but I'm going to start out by asking Kabir. because Qualcomm has funds for entrepreneurs, and so I thought it'd be helpful if you could describe what you guys are up to, both with respect to functioning as a DC in a way, and other opportunities for getting money from Qualcomm.
So Qualcomm has a ventures team, but within the ventures team, we have collaborated with the ventures organization to create a Qualcomm Life Fund. It's a $100 million fund dedicated to healthcare ventures that incorporate wireless technology in them. Normally, the way we do this is we don't actually go with brand new startups. We normally have kind of a 1 or 2 year mature startup that's already started making revenue, has customers lined up, and are now looking to scale. And there's a couple of investors in, and now they're asking us to join the pool. That's the kind of investment we normally look at. We don't normally go greenfield. But we do have other ways in which we invest or enable you to get funding from us. One of them is we have prizes, like for example, you might have heard of the Tricorder X Prize that we are doing. That's actually with the Qualcomm Foundation. That's not through the Qualcomm Ventures, but that allows you to participate and win awards. That's a $10 million award that the foundation's giving. The Ventures Fund also has prizes like the Q Prize that enables you to get $100,000 or $200,000 depending on how where you fit within the context of your particular category of prizes. We also partner with incubators. So for example, Rock Health has been a good partner of ours. There are lots of other incubators as well, as most of you might be familiar with, like Startup Health and Blueprint and others. One thing we always think of is if you have a really good idea, you don't need a lot of money to at least prove the initial concept and get that going. So if you have something cool that you're looking at, you should be able to at least get to a point where you're starting to get some traction, even though not from a monetary standpoint, but at least from a active user standpoint, from a user-based standpoint. That's also a good point to consult with us. I'm not part of the ventures team, but I can certainly connect you with the right people on our ventures team if you're at a point where you're starting to see scale and you want to get funding.
So any comments from the funders in the audience? Other perspectives, similar perspectives? Questions? Okay,
I
well,
will
so
say one thing with, you mentioned making sure that you have at least a concept that works or something like that. If you are doing clinical testing, just be very careful that you abide by the FDA regulations dealing with clinical testing. And there are a lot of old regulations that FDA has promulgated that you have to abide by. So sometimes you can get away and not have to file anything with the FDA, but you have to follow certain things such as full informed consent, have an institutional review board review the clinical testing or things like that. Clinical testing is testing in humans, and it's where you are actually invading the body of a human or doing something like that, where a diagnosis is going to affect the human. And that requires FDA, sometimes requires FDA review. A lot of times you're exempted from it, but just be careful if you venture into clinical testing and be cognizant that there are rules on that.
Other comments?
Just to add to that, clinical testing may involve just obtaining data and information from the patient. It doesn't necessarily need to be invasive per se. And so I'd just be careful in terms of not saying, oh, well, we're not, puncturing or putting any device on a person, just getting or obtaining some information from them may be enough.
We have a question on this topic.
Well, it looks like we're still going well, so I'm trying to change the direction again. We expect that, we all know that the healthcare is going to be changed by the technology over the next 10 years, big way, right? But all these regulations, they're slowing us down, especially the startups. It becomes very, very hard for the startup even to keep track of all these regulations. There's a chance there's a lot of companies who start deploying their apps in Europe or some other markets first, which will slow down a little bit further here. So can you guys give us some kind of ideas, like for the small guys, how we can even deal with all of these regulations and
It's a good strategy to go to Europe if the regulatory environment is too onerous here.
In general, no, because Europe has many more restrictions. You have to abide by all the restrictions in Europe. And in Europe, there are country-wide regulations in addition to Europe as a whole. So going to Europe a lot of times involves more regulation. And it just depends upon what you're doing. But I think your question was more about knowing where the regulations are and what they are. That's what, unfortunately, that's what lawyers do. We keep abreast of the regulations. And HIPAA and reimbursement, Tom deals with those all the time, and they change every single year. FDA, as I just pointed out, the FDA mobile health regulations have changed the last 2 years dramatically. You have to keep abreast of those, and you can do it yourself if you subscribe to the various websites that FDA websites and keep abreast of those things. But a lot of times you don't have time to do that. You don't want to know all the gobbledygook that FDA puts out, or that the HIPAA, the CMS puts out.
But doctors have the same problems. I was talking to doctors for 6 months, they have the same problems. They don't even know like how to stay compliant with all of these things and stuff. They don't
Well,
even know.
I think part of the thing is to get, it's putting together the plan. And why I think it's important to get whatever knowledge you need or can get. I will talk with clients who are developing something, and I said, you do not want to be subject to HIPAA. You don't want to be a business associate. You don't want to be a covered entity. Is there a way that we can preserve the value of what you're trying to do and avoid being regulated under HIPAA, and then we don't have to worry about it? I think Wayne would tell you the same thing with regard to FDA. Can we minimize or avoid? It may mean making a few changes, but maybe, again, planning to minimize or avoid some of the regulatory issues is the better way to go. But try to, again, instead of physicians providing diagnosis, can we have it that they're providing sort of education? How can we work to minimize and eliminate that? And I think the real message I'd like to leave with all of you is get that information or figure that out early in the game so you save yourself a lot of time and heartbreak than getting down here and saying, oh my God, now we've got to wait a year because we've structured it such a way we're going to have to get.
Is there any insurance that can cover startups in case of the risk of being sued because of a non-compliance with the HIPAA, for example?
An example of being sued for non-compliance. I'm not sure I have, actually I'm just trying to think. There was...
I think he's asking if there's insurance to protect you.
Oh, insurance to protect you.
In general, no, you cannot insure against, from the FDA standpoint, you have got to abide by whatever the FDA rules are. You cannot insure against it, so you cannot put a product on the market that violates the law. Sometimes the FDA will just take very little action. They may just give you a slap on the wrist or something like that. Or sometimes they will shut you down. But because FDA views it as they are the protector of the public health, they are the protector of the American health. So if you violate those laws, there's no insurance that can cover you on that. You can cover yourself on products liability issues, on those things, but from FDA regulation or governmental regulation, you can't really insure against that. Or an over.
So I just want to say that it seems to me, a lot of people spend time thinking about how they can avoid the FDA, or you say avoid HIPAA, but the serious problems that we have in healthcare. I think a lot of times people opt to go for apps and wellness and all this kind of stuff. They're not solving the serious problems. And I don't know, Kabir, if you want to speak to this, but it seems to me that I would say, yes, be sure you talk to the attorneys and you know what the regulations are, but I think that you need to do the work to get to the products that are really going to solve the difficult problems.
Spot on, and that's what I was, when you were talking about the fact that try to avoid HIPAA, try to avoid FDA, I actually look at it completely on the other side, which is make your product a differentiator by having, if you've gone deep in and you've done the due diligence, you've actually gotten yourself the right listing and gotten yourself the right protections within the context of that, goes back to what we just heard, which is even though it's cumbersome, even though it's very government-like and so on, ultimately they're just trying to protect the audience because they don't want people putting out products that claim certain medical miracles and then having the public kind of get deceived by that. So if you feel like there are specific products that you're developing that actually go deep on the medical side, genuinely can prove that, make that a differentiator. That's what we do from a context of what we're doing with TuneNet. It's listed with the FDA as a Class 1 MDDS. The goal there is to make sure that as long as you're meeting those claims, embrace it. To me, the fact that you suddenly go to the wellness or the fitness side and I'm just a virtual coach. I'm just telling you stuff, but use your own judgment to make that final decision. That in some ways you're softening up your product when it could really have a deep impact, and you could be lowering healthcare costs. You're creating something that could be something very, very useful.
And
yeah, and I mean, I do agree with that. I'm not suggesting that your goal should be putting together a meaningful product that fills a specific niche. If there can be done to mitigate or avoid regulation, that's great, but in some cases, it's just not going to happen. If Pat says, I don't care if we're going to have to get physicians who are licensed and give them malpractice insurance, I need to do it. I now know that the cost may be triple what I thought it was, but at the end of the day, it's going to be worth it. But you still need to be aware of what the regulatory issue is.
And this audience wants to make money, and a lot of the money, there's a lot of money in healthcare. They come in terms of reimbursements, for example, through Medicare, Medicaid, and so on, where it follows the exact same philosophy that Silicon Valley likes, which is give everything free to the end users, let them get free apps, somebody else is paying for it. Well, that exists in healthcare. You just have to be hardcore to be eligible for those reimbursements. So I would really seriously look at if you have something that's solving a medical issue that could replace a current medical process, embrace it fully, have somebody else pay for it, like the trillions of dollars that healthcare allocates for this, and make it free for your end users.
And so if it's okay if I get on my soapbox, because I love to do that, I also think it's really important. There weren't many clinicians in the audience, and there were people who raised their hands and said they were patients. But I don't know if you're the kinds of patients that are driving healthcare costs. It isn't the people who are going for colds and sore throats. It's people who have chronic illness or have catastrophic illness. And so I urge all of you who are working on medical products that aren't just fitness devices. And by the way, we have a ton of fitness devices. Let's work on the real hard medical problems. Go out and get some clinicians on your team, and then spend time talking to people who have those illnesses. And then the final piece of it that I think is really important, it's hard because it's a little bit of a moving target right now, is that you need to talk to people who understand how the money flows in healthcare, because I can't tell you how many entrepreneurs, I always like to say to them after they tell me they're a cool idea, and I love cool ideas. So how are you going to make money? And they say, oh, the insurer's going to pay. Well, that used to be my job, and I can tell you that 99% of the time I'll tell you the insurer is not going to pay for that. But somebody might pay for it, but you've got to identify it. So those are, all things that I think that you need to think about when you're developing your products. But I agree with you, Kabir, there's so much opportunity because there's huge problems waiting to be solved, and I think mobile health is gonna transform not just healthcare, but medical education and so many other aspects of what's driving healthcare costs.
Yeah, and I think there's a huge chasm between lots of cool entrepreneurs like in Silicon Valley that have amazingly cool ideas and just are very disruptive. They, in some ways, aren't contaminated by the old school ways of, how workflows work in the hospitals and providers. And then there's a big chasm, and then there's a lot of money on the other side that everybody's making through the traditional ways. Whoever builds that bridge across that chasm is going to make a lot of money. And you got to really if you want to go from the children's table to the adult table, you got to kind of get into the weeds on the other side of the chasm, figure out where the money is, figure out where you can make a difference and build that bridge. Because those are the guys who are going to really tap in. And because there's a complete dearth of on that front, hardly any people who've crossed that bridge, you could be among the first who's going to create that next wave of healthcare.
By the way, the people on the other side of the bridge are just now realizing that this revolution is taking place here in Silicon Valley and all the other places where we're innovating. And so in the past, I would tell you that organizations on the other side, like the American Health Insurance Plan, AHIP, it's the Trade Association for Health Plans, they weren't doing anything in this space. Now they're starting to. The Population Health Alliance, which is the trade association for disease management companies, is now starting to look at this. The National Business Coalition on Health, which are all the employer groups that purchase health care, they're starting to look at it. They're really just taking baby steps. Go hang out with these guys. Listen to how they talk and listen to how they think, because Kabir's right. They got the money.
The other thing is, a lot of things and now people think device innovation, but there's a lot of process innovation, there's a skill people innovation. You need to have those things. Really, healthcare needs more of that rather than just device innovations alone. That won't solve the problem.
Since I have the mic, can I squeeze something in? It relates to everybody's the apparent fear on some people, including the gentleman behind me, that there's too much regulations, etc. And there was a comment made that people didn't understand what the medical excise tax, and you said it was 13%. It's only 2.3%. It still sucks. It's ridiculous. There's no merit to it whatsoever, in my view, but it's only 2.3%. So
I just want to close the previous section. My question was related to the investors. Because of all these things, I have a hard time talking to the angels because they say, "Oh, in the medical field, we don't want to go there. Too many regulations." That's it. This is the problem.
So this is Keith Lance with Practive Health, but I'm also an angel with Health Tech Capital, who invests entirely in health tech companies. We see at least 5 companies a month that roll through. And by the way, none of them have any particular fear with regulations. They're just dealing with it. So there's lots of people out there, and all that Health Tech Capital does is healthcare angel investing.
More questions?
I have a question here for Kabir. Where are the opportunities for entrepreneurs?
So where's the money going? And yeah, give us a couple of areas of where if we were looking to do an mHealth startup, where would we go?
Yeah, if it's a near term, like if you're looking for something to build in the next 12 to 18 months, I would look at where the reimbursements are going. So if you look at, there's 2 specific areas, and the lawyers can tell you more on the specifics of it, but it's chronic disease management, we call it complex care management, and transition care management. So complex care management is managing diabetes, like a type 1 diabetic, for example, who could lose their limb if they stop taking care of themselves. Or it could be COPD, chronic COPD, CHF, and so on. That's CCM is what we call it. There's going to be a reimbursement that starts early January of next year, where physicians can get, I think, $40 or so reimbursement from Medicare. That's an example there. The other one is transition care management, where somebody's leaving the hospital, going home, but there needs to be continuity of care. So now you want grandma to no longer be tethered to the hospital bed and have her be looked after, and then the physician getting reimbursement. Normally what we see is when Medicare, Medicaid tend to reimburse things, the normal payers, the insurance providers, follow suit, and they start creating their own codes, if you will, that are allowed to cause reimbursements as well. So the quickest way for you, in some ways, if you're still agnostic about which path to go to, follow the money. See where government is starting to allocate, especially on the Medicare, Medicaid side, where are the reimbursements happening. If you create solutions around that and show a full viable business model where the life cycle shows that you've gotten all of the various entities in the supply chain bought in, and there's a solution there that meets a specific need, those are the kinds of companies we'd be looking for.
Let me add to that, because it's not only where the additional dollars are, but CMS, the government has this way of taking dollars away as well as providing them. And so now hospitals, if there's a readmission within 30 days, they don't get paid for that patient that's readmitted within 30 days. They are now very motivated to find an inexpensive way to really try to prevent certain things for patients not to be readmitted. So if there was some sort of a monitoring device or something that would give the physicians early signs of somebody's at risk for being readmitted, they would love that. So again, opportunity may be driven by where reimbursement, like Kabir is saying, is coming, new reimbursement, but it also is some box is going to get gored if they don't manage something better, and they'll take away the reimbursement.
And by the way, from the health plan point of view, it isn't just readmissions, it's any admission. That's the major driver of cost for health plans. So if you can come up with something that can keep people at home instead of getting admitted to the ER to the hospital, prevent readmissions, all these things would give you an opportunity to get the attention of a health plan. Somebody in the back of the room has a question?
Yeah, actually, my question is that the 30-day rule of readmission, I think the spirit of that rule was for the hospitals not to actually make that revenue proactively, meaning they should the hospitals should basically discourage the hospitals to make readmissions. It's not, I don't think the spirit of the rule was to actually prevent readmission. There are going to be readmissions of complicated cases, but I think the hospitals should be careful enough so that for the normal cases, the readmissions do not happen. I think that was the spirit of the rule.
Well, it's all about appropriately managing the care of the patient. So part of that is patients shouldn't be discharged too early. So in other words, make sure that they're stabilized and you're not discharging them just so that they're going to be able to come back in 3 days. But part of it is managing after they've been discharged. Are they taking their medications? Are they making that follow-up physician visits? Are they being appropriately monitored? So I agree with you, the hospitals, that's sort of beyond their control, but they're going to end up getting tagged for what happens.
So, so why the 30 days? Why not 15 days or why not 2 months?
The numbers guys just figured we could save this much money if we do this with
You
the 30
manage
days.
what you measure, and people measure the 30-day readmission.
Yeah, so the point I was actually trying to make is that the hospitals, I think the lawmakers actually have realized that hospitals are using readmission as to increase their revenue. It's by intention they're actually creating readmissions, and the law is to actually prevent that, not to prevent readmissions for complex cases. Readmissions are going to happen.
You have to, and this is where I think it becomes important to understand how the money flows. If you pay a hospital with a DRG, they may have a motivation to get people out early. If you pay hospitals on a per diem, they have a motivation to keep them in. So when you're designing your solutions, you do kind of have to understand how the money's flowing, how people are getting paid, down to a fair level of detail.
We're going to do one more question, guys, and then we'll probably wrap it up for the night. But you guys are welcome to hang out for a couple more minutes to ask questions for the panel. Last question?
Cool. Okay, I guess a round of applause, please, for the panel. Awesome job. Again, special thanks to folks on the panel, Arent Fox, Qualcomm. If you do, I guess obviously they do know their stuff at Arent Fox. So if you guys are looking for, and they're really cheap too. No, just, I guess you get what you pay for, guys. Definitely in upper. But also thanks to Microsoft, and also there's a MyTech table outside. Thanks to the folks from MyTech as well for sponsoring the table. I hope to see you guys next month. YouTube video probably up in a couple of days, so you can share with your friends, and also look for us on all the social media. Tons of Twitter stuff coming out tonight. So thanks for everyone for coming, and see you soon. Thank you.